Welcome to Civic Connect, your weekly guide to understanding your family rights, responsibilities, and the power of informed citizenship. Together, we'll explore the systems, principles, and actions that shape our communities and our country. With me is our resident civic educator, Mrs. Lynette Omondi. Karibu sana.
Asante.
And I'm your host, Victor Ochieng. We have mentioned that one of our objectives is to help the public understand family law rights. Why don't we begin by defining what a family is?
The family is the basic institution of the human society as ordained by God. It is constituted by marriage and is composed of two or more persons that are related to each other by marriage, as we have said, by birth, or by adoption. In traditional African societies, the marriage consisted of a man, his wife or wives, and their children. In modern societies, there are many types of families, and we'll explore some of these. Number one, the nuclear family. This is the family unit that consists of a man, a woman, and their children. That is the nuclear family. Next is the extended family. This is the family unit that consists of the nuclear family plus aunties, uncles, grandparents, and other relatives. Then we have the single parent family. The single parent family is the unit that consists of one parent and their one or more dependent children without the presence of their spouse. This spouse who is absent may or may not be lending support to the family. Then we have the childless family. This is the family which either do not or cannot have children. This means that they do not want children, or for medical reasons, they may not be able to get children. Then we have the step family. This is the family unit that is formed on the remarriage of a divorced or widowed person and includes a child or children. There is also the grandparent family. This is the family where the grandparents are the primary caregivers. They either take care of the children on their own or with the help of other family members. Then we have the blended family. The blended family is the family unit that consists of a man, a woman, and the children that they have had together with the children that they have brought into the marriage from their previous relationships. Lastly, we have the same-sex family. Same-sex families are families in which persons of the same sex raise children that they have adopted or that were conceived in previous heterosexual unions or through third-party donation. This kind of union is not recognized by the Kenyan law, and therefore it is still illegal in Kenya. But we cannot bury our heads into the sand and say they do not exist. We cannot say same-sex families do not exist. That's why we are exploring or examining them in this context.
Awesome. So 8 types of families. We have nuclear, we have extended, we have single parent, we have childless, we have step family, we have grandparent, we have blended, and we have same-sex.
And those are just a few.
Oh, those are just a few?
Yes.
Wow. Okay. So I'm assuming that in future we'll explore some of the others?
We might.
Okay. Now, having mentioned the different types of families, what are some of the functions of a family or the functions of these different types of families?
The family is for the physical maintenance and care of family members. That includes bathing, cleaning, cooking and serving, and physical protection. That is the physical maintenance and care of family members. Number 2, the family provides for the nurture and socialization of children. That is the process of teaching children to behave in a way that is acceptable to the society. Number 3, the family provides for the nurture and love of children. This means to take care of and protect somebody while they are growing up. Number 4, the family provides for the social control of its members. This is in the process by which a group regulates itself based on its values, principles, and belief system. Next, the family facilitates the addition of new members to the society through adoption and procreation. Next, the family gives social status. In many communities in Kenya, a person is not considered an adult until they are married. Once they get married, the family gives them status. Lastly, the family regulates sexual access and activity. Those are only some of the functions of a family.
Amazing. Now, I'm sure in regards to family, there are laws that have been constituted that are there to protect family and to guide the dynamics within family. What is the purpose of family law?
The purpose of family law is to regulate and protect the rights and responsibilities of the family members. It also ensures their well-being. It is concerned with the rights of the couple and their children and the duties of the couple to the children and to each other.
And we know that families are constituted by marriage.
Yes.
So I'd like to know, how does the law define marriage?
The law defines a marriage in an interesting way. The law says marriage is the union, the voluntary union of a man and a woman, whether it is a monogamous or a polygamous relationship.
Monogamous or polygamous?
Monogamous means marriage to one spouse, the marriage of a man to one spouse at a time.
And polygamous?
Polygamous means the marriage of one man and 2 or several wives simultaneously.
Okay. What types of marriages do we have in Kenya?
We have quite a number of marriages in Kenya. Number 1, we have the customary law marriages. Customary law is not homogeneous, but there are many communities in Kenya, and each community has their own set of marriage laws. So number 1 is the customary law marriages. Number 2 is the civil marriages. That is the marriage that is celebrated before the registrar. Then we have the Christian marriage. This is the marriage that is celebrated in churches by a pastor. Then we have the Islamic marriage. These are the marriages that are celebrated by parties who are Muslims, before a sheikh, before an imam or a mufti. Then there is the Hindu marriage.
Sorry, you said an imam or a?
Sheikh,
an imam
or mufti. M-U-K-H-I.
M-U-K-H-I.
Yes.
Okay. All right, let's proceed.
Did I mention the Hindu marriage? Then there is the Hindu marriage.
Islamic?
Is the Islamic marriage. So, now we go to the Hindu marriage. This is celebrated by parties, one or both of the parties that are Hindus. And it is celebrated by the Hindu religious community officials. Then lastly, we must mention the presumption of a valid marriage. A presumption of a valid marriage in Kenya is a legal inference that a couple is married even if there is no evidence. It is a form of marriage that is now common and is sparingly recognized by courts of law. It is called cohabitation or come-stay marriage. In courts of law, it is known as presumption of marriage. In this kind of marriage, the man and the woman agree to live together as husband and wife and are regarded as such by their community, but they have not celebrated their union under any law. The parameters within which a presumption of a valid marriage could be made are as follows. The parties must have lived together for a long time, that is, a period of 2 years or more. The parties must have the capacity to marry. That means they are 18 years of age and are not related to each other by blood. The parties must have intended to marry. There should be no coercion or fraud involved. Both parties must have intended to marry, and there must be consent to the marriage by both parties. The parties must have held themselves out to the outside world as being a married couple, and there should be a perception in the eyes of others that they are married. Their case is further helped if they have children. In past cases, the courts of law have held that such unions are marriage, and the parties to such marriages have been accorded the same rights as those due to parties who are formally married. In recent times, the courts have had to review their position because the law requires that all marriages be registered, including customary law marriages. So the courts are asking, why should we lend the status of marriage to marry to unions which are presumptions of a valid marriage? Why should we? Why should we, when in fact they ought to have been registered at the outset? Secondly, the courts are asking, why should we force parties to a marriage when they don't intend to? Two people could be living together in the same house, and yet their intention is not marriage. So the courts are recognizing these unions, but sparingly so. Sparingly so, because first and foremost, they ought to have been registered in the first place.
So what I'm getting from that is, in a situation where the courts would have to mediate between two people who have cohabited for more than 2 years,
yes,
the courts would view them as a married couple. But what you're saying is, generally the courts are not very much in favor of presumption of valid marriage.
Yes.
Or sparingly in favor.
Sparingly. Because in the first place, these parties, whoever was married under customary law before the Marriage Act of 2014 came into force, they were given a period of time within which to register those marriages. Mm-hmm. After that, anybody who is getting married under any system of law, the ones that we have mentioned, all of them, each of the parties getting married must register their marriages with the Registrar of Marriages. So there is really no room for parties to cohabit and consider themselves married. But there are instances when the courts of law will lend recognition or marriage status to such unions, but sparingly so.
Okay. All right, and as we wind up, I'd like to know, what are the sources of the laws that govern marriage in Kenya?
There are many sources of laws. Number one is the customs and traditions of the different communities with regards to marriage. Each community has got its own traditions
and customs that regulate their marriages. So these form part of the laws that are recognized to govern marriage. Next, we have the statute, the Marriage Act of 2014. This law regulates all marriages, but there is an exception. Where this law does not agree with the Islamic laws of marriage, the Islamic laws of marriage will have an upper hand. Otherwise, the Marriage Act of 2014 regulates all marriages in Kenya. Thirdly, we have case law. When a court of law makes a decision with regards to marriage or any other issue, those decisions are recorded. And courts which are subordinate to the original court must agree in their decisions when they have similar facts. What I'm saying is, a higher court makes a decision with regards to a matter. In future, whenever subordinate courts are faced with a court case of similar facts, they must arrive at a similar decision to that of the higher court. So case law also forms part of the laws that govern marriage in Kenya.
Wow. Okay. So those are the sources of the laws that govern marriage in Kenya. Thank you so much for that. What topic will we be tackling next week?
Next week, we shall discuss the legal requirements of a marriage under the different marriage law systems. These requirements have to be fulfilled for a marriage to be valid under the law. We shall also discuss breach of promise to marry, objections to a proposed marriage, consequences of an invalid marriage, and if there is time, we shall consider the annulment of marriage.
Okay. I'm looking forward to that. Thanks for tuning in to Civic Connect. Remember, civic engagement does not stop at the end of an episode. Stay informed, stay active, and together, let's build a stronger, more engaged community. See you next week.